Calendar for the day. The first bill on the calendar for the day is House File 2725. The clerk will report the bill.
House File number 2725, number 1 on the calendar for the day, an act relating to judiciary, the second engrossment.
I recognize the author of the bill, the member from Hennepin, Representative Edelson, who will explain the bill.
Madam Speaker and members, House File 2725 is the result of comprehensive work done by the Community Competency Restoration Task Force that was created by this legislature in 2019. This task force included 25 members and appointees from organizations and government entities that included NAMI, the county attorneys, DHS, the Sheriff's Association, State Court Administration, the Board of Public Defense, Association of Counties, and many others. I want to specifically thank Sue Abder-Holden and Elliot Boutte from NAMI, Ryan Flynn, Nancy Haas, and Bob Small from the County Attorneys Association, and Bill Ward from the Board of Public Defense for their collaboration in this process. Their work has been instrumental in building this bill before you today. Members, this bill seeks to address what are known as gap cases within the criminal justice system. This is when a person commits a crime but is not competent to stand trial. However, they also may not meet the civil commitment standards and subsequently are often released into the community with little treatment or supervision after committing a crime. Judges, prosecutors, defense attorneys, law enforcement, therapists, families, all faced with little authority to ensure that this population gets the stable help they need. This bill before you today is a critical step in building an infrastructure that will bridge a substantial gap we have in treatment and public safety within our legal and mental health systems. Experts in the area, as well as my bipartisan co-author, Representative Albright, and I have worked tirelessly on this legislation before you today. Some for years and others for at least the last 6 months. This bill does a great deal of critical improvements to our justice system, as well as our mental health system. Most importantly, it separates the commitment process from the competency process. The bill before you today creates a process and statute when a person is found incompetent to proceed with their trial because mental illness or cognitive impairment. Right now, these provisions only exist in the rules of criminal procedure, and they are outdated and insufficient. It establishes standards to assess a person's competency to stand trial and a process for restoring a person's to competency. It creates a board of competency restoration that would operate independently from the courts, a board modeled after the guardian ad litem program. It designates the Competency Restoration Board to hire 1 director, 2 managers, and 127 FTE staff to train for the position of a forensic navigator and competency educators. It authorizes navigators to have a presence in all 10 judicial districts throughout our state. It ensures that our courts have the authority to assign navigators to cases, to develop a bridge plan, and ensure that judges' orders are being followed. It creates an infrastructure for navigators to connect the defendant to treatment, service, housing, and medication. It ensures a plan for navigators to be responsible throughout this legislation, except in some circumstances, for delivering competency restoration services, meeting the education piece that will provide defendants an understanding of how the trial and court process works. It allows the bridge plan to be ordered by the court and, at the end of a criminal case, help a defendant transition back into the community in a way that encourages lasting stability. It also provides the court authority to order defendants to competency restoration programs according to the needs of the defendant and public safety. It creates a very important process to address people who are likely never to become competent to stand trial due to the nature of their cognitive impairment. This could be somebody with a developmental disability or dementia, for example. It provides clear timelines and directives on supervision for a defendant to protect the community and constitutional rights of the defendant based on the charges. And lastly, this legislation puts Rule 20 into the rules of criminal procedure into statutes. Members, I would like to acknowledge Paul Pfeiffer's family sitting in the gallery today. Paul was struck and killed in a hit and run in what was later determined to be a car that was driven by his neighbor, Mr. Rice, who struggled with severe mental illness. He was released on a provisional discharge. I have talked to Joseph, Paul's husband, who is standing up, that this is an area we must tackle in depth in the years to come. He was a Catholic, and he ministered in the church with his music. Paul believed in the intrinsic value that all human life matters. Paul is also someone who struggled with mental illness himself. It is Paul's family's firm belief that Paul's prayers would include Christopher Rice, the man that killed him. While this legislation would not have necessarily saved Paul, it would have absolutely interacted with Mr. Rice to some extent and provided another layer to protect the public. I want to personally thank Joseph, Paul's husband, for your commitment to improve this system in your husband's name. Please know how deeply sorry we are for your loss. With that, Madam Speaker, I would like to yield time to Representative Albright, my co-author, to finish our opening.
The member from Scott, Representative Albright.
Thank you, Madam Speaker. Members, I too would like to extend my gratitude to Joseph and your family and friends for being here today to witness the passage of what I'm sure is a very important piece of legislation in the lives of a number of families across the state. So thank you for being with us today. Members, the bill that you see before you is a thoughtful, comprehensive piece of legislation. Some might consider it complex, but it has to be, because it's going to put in place a foundational element of law that's going to promote public safety, as well as address the systemic failures in this state's treatment system for those who are found incompetent to stand trial for the offenses they've committed. To be very candid, though, the bill you see in front of you today is not the be-all, end-all to the process that the stakeholders have undertaken over the last several years to bring this bill to this point. It is, however, a very integral first step in rectifying the problems faced by so many under Rule 20. And as we've heard before from the media and from news reports, the Rule 20 gap cases. In 2019, this legislature authorized the creation of the task force that revealed the gaps, if you will, in our obligation to provide not only for that public safety in our communities, protect the due process rights of every individual, but also to make sure that if you are in need of restoration to competency, you realize the appropriate course of treatment so that you can stand for the charges brought against you. This is not a simple bill, nor is it perfect, but it is necessary. Let me reiterate that by once again reminding us all who was at the table to make this bill a reality. The judicial system, the county attorneys, law enforcement, state agencies, hospitals, therapists, clinics, as well as the families that have been so tragically impacted by the failure of the system to protect. They all recognize that we have an inadequate system, unable, candidly, to respond in a meaningful way because of the lack of substantive and, dare I say, accountable infrastructure. The legislation that we are about to pass into law will be a foundational and very meaningful part of what I hope this legislature in years to come will build upon. I want to thank the members of the various committees that we have presented this bill in front of. Your encouragement and your criticism and help in making substantive changes has made it much, much better. And so we thank you. Members, this is the conclusion of a long road. I hope that we conclude on a very high note for the families affected. Thank you, Madam Chair.
There are no amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File Number 2725.
Third reading. Discussion to the bill. The member from Isanti, Representative Johnson.
Madam Speaker, members, I want to thank Representative Edelson and Representative Albright for tackling this issue. It's very complicated, very complex, and very much needed. Is this a perfect bill? Absolutely not. But it's much better than the system we have right now. Right now, these people are placed on the streets by DHS, leaving them there, not helping them. This is the way this bill starts the process to getting those people the help they need. It doesn't go in effect for a number of months, but we will be, and unfortunately we will be addressing this again, as this program is brand new, never been done before. We know there's going to be some issues that we got to fix. There's also going to be another part of this bill in this process, not on the criminal side, but on the civil side that we have to deal with, and they're still working on that. But at this time, we do need to get some things in place for those on the criminal side to make things better for them, when possible, hold them accountable. But the main thing is to get them the help they need. Law enforcement has been screaming for something like this for decades, and I'm glad that it's finally here. Thank you.
The member from Anoka, Representative Scott.
Thank you, Madam Speaker, and thank you, Representatives Edelson and Albright for working on this, and thank you to the stakeholders as well. I know that this bill took a lot of work and a lot of negotiating and back and forth, but I do just want to be on the record with some concerns with the bill, and one of them has already been mentioned, and that this bill does nothing to address DHS's unilateral move to provisionally discharge civilly committed individuals, patients. No one is responsible right now for helping those people that are living amongst us. No one's checking in on them right now to see if they might be a danger to themselves or others. That's a big concern for me. And it's my belief, at a very minimum, we should have at least required DHS to pick up the mantle on that again, at least until we can find a permanent solution when it comes to this issue of those that have been provisionally discharged. I will be supporting the bill today, but again, with these reservations. I also have concerns from a public safety aspect, that there may be some people that are still dangerous that are going to be released. Those people that are supposed to be getting help on an outpatient basis, I might have concerns of them, adhering to the bridge plans and the different plans that are set forth in this bill for them to follow. And I have a concern with our workforce shortage that there just aren't going to be enough mental health professionals to fill these forensic navigator positions. There's talk of, I think the fiscal note said that there would be up to 12 per county. That's a lot of people. And we already have a shortage of people in the mental health space. So I have grave concerns about this. It seems like it's maybe an overly complicated solution to an issue, and I understand this is a complicated issue in and of itself. So I certainly hope that we will keep a close eye on this to see if it's working. And the one thing that it still doesn't do, in addition to the provisional discharge folks, is between now and the time that this program is set up, there's nothing. There's nothing that's really watching out for these people and keeping the public safe. So again, I'm voting in favor because I believe some first steps need to be taken, and I hope that in the future we can address this issue in its entirety, continuing to work with stakeholders. Thank you, Madam Speaker.
The member from Wright, Representative O'Neill.
Thank you, Madam Speaker and members. A little over a year ago, there was a horrible tragedy in my district. The clinic, the Atlantic Clinic in Buffalo, was attacked with 4 bombs, an arsenal of weapons, not an arsenal of weapons, it was one weapon, it felt like an arsenal. It was 5 people were shot, 1 person was killed, tragically. And when I started to unwind all that and to take a look at what actually happened, we had a doctor who took out an HRO, so harassment restraining order, because a patient had been following him, threatening him. He had told the court exactly what he was going to do. He told the court he was going to blow the place up, that he was going to use weapons, and he was going to hurt people, so much so that the media would finally pay attention to him. And he did exactly what he said he was going to do. Now, within 2 weeks of the harassment restraining order being issued from the bench, he violated. And that violation was a misdemeanor. And in this bill, it would be a targeted misdemeanor. So I want you to pay attention to that, a targeted misdemeanor. It's not a simple misdemeanor. And maybe Representative Edelson can explain more in a minute what the targeted misdemeanors are, because it's really important. It's lumped in with the gross misdemeanors. But in any case, he violated, he had a targeted misdemeanor according to this case. And what did not happen is that a judge did not make a finding that he was mentally incompetent to stand trial. Now, our prohibited person statute, 624.713, so you're prohibited from owning, possessing, or purchasing guns, says if you have been found incompetent to stand trial, you cannot possess or purchase weapons. There was no finding because a city attorney dismissed the misdemeanor. Now, in this bill, once a finding has happened at the court, that misdemeanor is still dismissed. And there's a distinction between just a simple misdemeanor and a targeted misdemeanor. But in this case, it would have to be a judicial finding, which is the trigger for a prohibited person. So that is in here. I want you to know that that is in here. But my concern is this. What happens after? So his gun rights will be taken away because if you are found incompetent to stand trial, you are a prohibited person. And that does happen in this. And it happens for all misdemeanors in this, because if you're found incompetent by a judge, you are a prohibited person. But what I don't know what will happen in this bill is that when you've got a targeted misdemeanor or a gross misdemeanor, it says that the judge must dismiss within 30 days of the competency finding, so once the report comes back. But here's the thing about court. So if the charges are dismissed, then the court doesn't really have any say over your life anymore. So if Representative Edelson would yield for a question, I just have a quick couple questions.
She will yield. Representative O'Neill.
Thank you, Madam Speaker. So Representative Edelson, in this bill, I appreciate the fact that you did get to the specific situation in my district. And with a targeted misdemeanor, if you'd like to speak as to what targeted misdemeanors are, that'd be great. But most importantly, what happens after the misdemeanor, the gross misdemeanor, the targeted misdemeanor, and even eventually the felony? What happens after those are dismissed? What happens with this person that may or may not be competent, who may or may not still be dangerous? Because there's no connection, if I understand this bill correctly, connection to civil commitment. So what happens with that person?
Representative Edelson.
Thank you, Madam Speaker and Representative O'Neill. I watched what happened in Buffalo, and that I think we all did. Eyes were on your community, and that was a terrible tragedy. So with the targeted misdemeanors, things like HROs, making sure that we would have this under this bill, it's for 1 year we would be able to actually have that case open. And with the navigator on that, making sure that we are connecting with stable housing. The really critical thing in this bill does is it separates civil commitment from the process right now of competency restoration. So right now, under competency restoration, in that case where it happened in your community, I don't believe he was civilly committed. The judge would not have been able to order medication. We actually taking the Jarvis, which Representative Johnson, you talk a lot about the Jarvis order, which only applies to civil commitments. This would not only allow us to stabilize that person, but also ensure that they are getting the medication and the navigator would be watching them. And hopefully that answers your question.
Representative O'Neill.
Thank you, Madam Speaker. Thank you, Representative Edelson. If you'd continue to yield.
She will. Representative O'Neill.
Thank you, Madam Speaker. So really the question, Representative Edelson, is what happens after these charges are dismissed? Because then the court doesn't really have anything to tie to say, okay, we've got this charge, because now that charge isn't there anymore, right? So that's what dismissed means. So what happens with the navigator? What happens with all of the court-ordered treatment and follow-up? At that 1 year or even 30 days, in the case of the targeted misdemeanor, gross misdemeanor, just after 30 days, it must be dismissed. So then what happens?
Representative Edelson.
Madam Speaker, Representative O'Neill, in that instance, the person does have constitutional rights, which is something that we, trust me, went back and forth on. The reality is we have laws in our books that we have to follow. We cannot follow somebody into perpetuity because they have mental illness or because they have committed a crime. We just cannot do it. So, we struggled with that, though, I promise you. The county attorneys, we went back and forth with NAMI and trying to figure this out with the Board of Public Defense. These are not easy situations that we're talking about. The instances where somebody may be dangerous, it's honestly what happens is we hopefully stabilize them. We connect them to services, we get them in a good place where hopefully they're not going to commit a crime, and we off-road them, which is right now not happening. They're just cycling through this system in and out, and it's costing Minnesotans a lot of money, and it's also putting our public at risk. So what we have here is a really good solution, and again, hopefully that it provides a little bit more context.
Representative O'Neill.
Thank you, Madam Speaker. Well, so that's exactly my concern. So let's just take a step back. We have mental health courts, we have drug courts, we have veterans courts, and the reason they work is because they extend quite some time, months, sometimes over a year. And, I spent a lot of time before I was the author to expand specialty courts across the entire state. I spent a lot of time sitting all day in court, reading court cases, listening to the arguments, looking at the charges for those that were sitting in mental health court specifically, and for drug court. And the reason it works is because they're connected to the court for such a long time. My concern in this bill is 30 days. 30 days just isn't enough. Look, I told you many times I worked at Minnesota Adult and Teen Challenge, and I can tell you, for someone that has addiction issues, and there's a duality sometimes, there's the dual diagnosis of both addiction and mental health, and they cross over, especially when you're talking about criminality. There is a plethora of crossover there. So when you've got someone that is getting sober, my experience at Teen Challenge was frequently that it would take about 3 months to get to the place in their life where they were actually free of the chemicals. And at that 3-month mark, you'd see something very interesting at Teen Challenge. You would see people absolutely struggling, just struggling with their emotions, struggling in their daily thinking and acting, and they wanted to leave so badly. So my concern in this bill is it's only 1 month. It's only 30 days, and then the charges are dismissed. So that's my concern. It's 30 days and charges are dismissed either with a targeted misdemeanor or gross misdemeanor. And I suppose you could extend it a little bit. There are some provisions that if it has to be extended, but my concern is that we have mental health court, we have drug and alcohol treatment courts, and they work really well because there is this long extended relationship with courts, and there's accountability. My concern is that doesn't really exist here because once the charges are dismissed, as you had said, Representative Edelson, that the courts really don't have much say into that person's life anymore unless they commit a new crime. So unfortunately, I'm a no today because this bill just doesn't quite get to where we need to get to. There isn't this handoff to the civil commitment side, and maybe there can't be, I don't know, but I don't see this as the solution to a very, very big problem. Part of the biggest problem is what Representative Scott already talked about with the lack of care with DHS. We don't have community options like we need to. We shut down our state hospitals in the hope and prayer and promise that we would have community options, and we don't. We just don't have that infrastructure that's been developed. This doesn't do anything to address that as well. So this may take us a few steps in that direction, but quite honestly, most of this is already in not in the court procedures, Rule 20, there's many rules that are already in here. So I'm a no, I'm sorry, but this just doesn't take it very far enough. It's also not enacted till 2023. We have more time to maybe just take this just a little bit further. Thank you, Madam Speaker.
I recognize the member from Ramsey, Representative Pinto.
Thank you, Madam Speaker, and thank you to Representative O'Neill for that line of questions. I have to say I firmly disagree with her. I know she spent a lot of time in court. I spent a lot of time in court as a prosecutor, and I can say that this is desperately, desperately needed. We should be so grateful to Representatives Edelson and Albright for their work. This is how lawmaking should be, members. This is a set of really complicated areas. Public safety on the one side, mental health issues on the other in the court system there. And what we have is a giant gap between them. And I think it's important for folks to really understand the gap we're talking about. On the one hand, I would hope we would all agree that it is unconstitutional. And whether you agree with it or not, this is true. It is unconstitutional for somebody to go through criminal proceedings without understanding what's going on. You need to understand what's happening. And if somebody doesn't, then that's when there has to be this pause on the criminal proceedings. On the flip side, it is also unconstitutional for somebody to be, or we have this setup where somebody cannot be held in custody under civil commitment and be civilly committed unless they have shown themselves to have a mental illness that has caused them to be dangerous to themselves or others, and to have that connection. Can't just be dangerous in general. There has to be a connection in terms of their mental health. We, of course, have the thought that if somebody's dangerous in general and they commit some sort of crime, now we're on the criminal side. But what happens is when you take those two doctrines, put them next to one another, there is a really big gap between them. And it's something that prosecutors and many others encounter all the time. And I remember the first time that I encountered this, I said to my colleagues, wait a second, so we can't go forward with the criminal case, but the person can't be civilly committed. So what happens then? And the answer was sort of a shrug of the shoulders, because we don't have the legal tools, the policy tools to deal with that. The bill in front of us gives people the policy tools they need to do it. And you heard Representative Edelson's list at the beginning of who's participated in putting this together. A vast array of people from a vast array of perspectives. I understand some of the concerns about picking apart different details. Representative O'Neill was mentioning there being 30 days. The 30 days is for prosecutors in lower level cases, targeted misdemeanors, gross misdemeanors, to have the time to decide they want to prosecute. It's not 30 days only for anything can happen. We know those can be very serious cases, even though they're lower level penalties, certainly. But 30 days should be enough time for a prosecutor to decide they want to prosecute. And then the case is held so that we can go forward with that case as the person is restored to competency. But right now, it's a system that is extremely fragmented and is a real mess. And what we have is a group that's pulled a lot of pieces together so that we can fix that. Representative Albright pointed out, and others have as well, this does not address every single problem with this system, but what it does is it establishes an infrastructure and a foundation so that as we put this in place, we can then move forward to the rest. But right now, there is a yawning chasm between these different really complicated areas that is causing a big problem and is making Minnesotans less safe. So in voting yes to this bill, members, you will be making a big step forward to having Minnesotans be safer. You're being asked to do so by police, prosecutors, defense attorneys, civil liberties advocates, mental health experts, and many, many others. Please join them and join Representatives Edelson and Albright. Thank you so much to them for their work in voting yes on the bill. Thank you, Madam Speaker.
Further discussion to the bill. I recognize the author, Representative Edelson.
Thank you, Madam Speaker and members. The system we have right now is not working, Representative O'Neill. You and I don't sit in the courtrooms when judges are pleading for us to do something. We have county attorneys here begging us, please do something. They are watching people come in and out of a system that does not work for them. I wish we could enact it earlier too, but we're trying to be mindful of what is actually possible here. We have spent, judges, law enforcement, attorneys have spent a year and a half working on this. We have gone through numerous committees. It is bipartisan. I thank you, Representative Albright. You will be missed in this chamber. Let me just make sure I say that. To the point that you were mental health courts, I just want to address that you have to be able to say you can plead guilty. And when you're incompetent to stand trial, you can't do that. You can't do that, and I know that you know that, Representative O'Neill. This is a really important piece of legislation, and I realize that it's very wonky and it's really technical, but it's important, so I ask for your yes vote. Thank you.
There being no further discussion, the clerk will take the roll on the bill. Members, please vote. Will the clerk please call the names of those members who have not yet voted?
Bo, no. Davids.
Davids votes aye.
Davids, aye. Freiberg.
Freiberg votes yes.
Freiberg, aye. Hamilton.
Hamilton votes aye.
Hamilton, aye. Hassan. Hassan. Hausman.
Hausman, aye.
Hausman, aye. Her.
Her, aye.
Her, aye. Igo.
Igo aye.
Igo, aye. Keel.
Keel, aye.
Keel, aye. Katiza Watun.
Katiza Watun, aye.
Katiza Watun, aye. Mariani.
Mariani aye.
Mariani, aye. Miller.
Miller, no.
Miller, no. Moran.
Aye.
Moran, aye. Olson B.
Wilson B, no.
Olson B, no. Pinto.
Pinto, aye.
Pinto, aye. Sandsted.
Sandsted, aye.
Sandsted, aye. Schumacher.
Schumacher aye.
Schumacher, aye. Thompson.
Aye.
Thompson, aye. Speaker Hortman.
Speaker Hortman, aye.
Speaker Hortman, aye. Hassan.
She's excused now.
Excused.
The clerk will close the roll. There being 102 ayes and 31 nays, the bill is passed and its title agreed to.